sponsored. Many of you have gotten emails from me, perhaps more emails than were necessary or desired. I'll say a few words, but right now I'll just say welcome to our 6th annual conference sponsored by the Center for Business Law, and this year co-sponsored by the Women's Law Caucus. And I'd ask Dean O'Brien, our dean, for nearly 30 years, the longest serving dean of any law school in the United States, to say a few words.
Thank you. Not sure what it means other than I refuse to leave. But at any rate, I first want to thank Professor Monserud, who I know lives and dies with this conference, and he's put so much of himself into it that I really couldn't begin any other way other than by thanking Professor Gary Monserud. So thanks, Gary, for such a good job. Also want to welcome everyone here, and there will be students and others kind of rolling in and out through the day. They have classes and things of that sort. I'm sure everyone is excited about what we have here. I want to thank the panelists for helping us move this all along. Also welcoming back one of my favorite people in the world, Professor Emeritus Kurt Nyquist, who you will enjoy hearing from, because not only is he interesting, he's also funny, so you better, because now I put you on the spot.
Legal realism is so humorous.
What is your famous quote? I refuse to teach that which I don't know, or something?
I refuse to teach more law than I know. I may use that a couple times.
Also, someone who taught me criminal law in 1974 and is an emeritus faculty member, Dick Child, has come back. So Dick, nice to see you, and we hope you come back more often. So thank you very much. So this is our 6th annual conference, sponsored by our Business Law Center. And this year we're really pleased that the Women's Law Caucus has decided to co-sponsor it, and we're very grateful for that. Also wanted to, in addition to welcoming everybody and thanking you for being here, give a little bit of a plug, because although I realize this year the conference is on theory in the classroom and in the practice, which is important, but which has also been traditional in the way law school is taught and perceived. We have, we hope, a little bit of a reputation for putting lawyers on the street who are practice ready. And the people who will be talking today and our Business Law Center really have been instrumental in not just teaching theory, but making sure our graduates are practice ready. And one of the things that we've instituted recently that the Business Law Center has really been instrumental in implementing is, after the first year, we pay for any student who's able to obtain employment, and we facilitate most of that ourselves, in a law firm, agency, or other area where they can get legal training. We don't get any U.S. News World Report credit for that. We don't get anything other than our students get to work. The people who are willing to give them legal experience are able to have people there to work for them, and we pay, which seems like a pretty good deal for everyone all around. And some of you folks who visit us today who might be interested in that, we have students all around the country, and if that fits with you and if it gains legal experience for our students, we are the ones who pay the stipend, because we think it is that valuable that they leave here knowing what it is to practice law. So I've taken enough of your time. I'm so happy to see all of you here. Again, thanks to Professor Monserud, and thanks for being with us.
Thank you, Dean O'Brien, for your support, and for the deposit, automatic deposit every other week. Eric Lustig, the leader of our Center for Business Law, say a few words.
Thanks, Gary. So my name is Eric Lustig. I'm the director of the Center for Business Law. We're co-sponsoring this conference. Thank you for coming. Gary, thank you, and thank Lisa for the efforts for putting this together. Thank our panelists. Thanks, Kurt. I wanted to echo a few of the things the Dean mentioned. One of the key things that we do in the center is help our students get ready for the practice of business law. One of the driving parts of that program is the experiential aspect to our program. So we have the Summer Fellows program, which has been wildly successful. And anyone who's interested and has potential placement, please contact either myself or Peter Carroll. And we will gladly work with you on that. We also have, in terms of curriculum, we have the business practice credit, and we have our business and intellectual property clinic, which is a fairly new clinic. We have a fair number of placements with that. So please let us know if you have potential placements, and we'll certainly work with you in terms of finding students for that. So enjoy the conference. I know I will. This is a little bit outside the box from the norm, as the Dean mentioned, but very important as we rethink what we do in the classroom and why we do it. Really important. So I look forward to it. Thank you. Thanks for coming.
Now, we want to start as near to 1 as possible, but there are a few persons who I want especially to recognize. My co-chairperson, Professor Lisa Freudenheim. I will moderate the first half of the program till 3 o'clock. We'll have a break at 3 o'clock, and then she will moderate from 3:20 on, and during the last session, she will sort of wrap things up. As Sarah Venegas, she's the president of the Women's Law Caucus. Just a wave to you, thank you. I'll mention specifically our student helpers later, and I see a couple guys sitting together whom I want to recognize. Attorney Steve Chow from Burns Levinson. He's been at every conference, and last year presented on Bitcoin, much in the news. And adjunct professor, attorney Frank Morrissey has been at every conference and moderated a panel, I believe, 2 years ago. This is Professor Steve McChon. He'll be here in a bit. Professor Ingrid Hillinger, always a supporter, and has moderated panels in past years. Thank you so much for coming. Now, just the logistics, restrooms straight out here, down to the right. A little preview of the program. We'll start at 1. We'll have 3 speakers, 40 minutes each. I don't mean to be obnoxious, but I will set times, and I really feel I hate to interrupt speakers. We've got excellent presenters. It's just the only reason is it wouldn't be fair to the persons who follow. And then at 3 o'clock, we'll break off, and we'll have a 20-minute break. Then we'll start at 3:20. Professor Freudenheim will moderate, and we'll go on to about 5:30. Now, this is being videotaped with the consent of all the speakers, so mind the videotape, try not to block it out too much. Just a few words about my own thoughts here respecting the conference. We've always built it as a conference, and what I'd like to say is I really think of it as a party. It really is a law party. You should really relax, reflect, chat with one another, focus on something that I think we all think is important. That is the teaching and practice of law. And we'll get each other's impressions, and I'm sure have a very pleasant afternoon. Now, this idea, the importance of theory in the law school classroom and in practice, really comes from Professor Emeritus Kurt Nyquist's article. And so we started building around that and found some excellent presenters, but we thought last summer, Professor Freudenheim and I thought we need an opening speaker. And we looked about and we thought, a couple of candidates here, and so I called Ingrid Hillinger. And one of the names that came up was Professor Phyllis Goldfarb, and she said, capture her, if you can capture her. And we did. And I'm so pleased about that. She said it would be okay to distribute one of her articles, far off to my right. We've got some articles that air on this conference, 3 articles from Professor Nyquist, an article from Professor Goldfarb, an article from Professor Fleming, And then to the far left, for those of you who are teaching or have a scholarly bent, a number of articles about Wesley, Newcomb, Holfeld. Very important, but maybe not a household word in America. You can talk about that. All right. So, we're about at 1 o'clock. If there's questions. Okay. I can say a lot more about Professor Goldfarb, but her bio is in the program here. It's on page 8. I know she's thought hard and deep about law and practice and theory. So, it's all yours.
It's a delight to be here. It's an honor to be asked to kick off this program. Although I didn't grow up in New England and haven't lived here for several years, I did spend a couple of decades at Boston College, so I still consider Boston my home. So it's great to be back home. It's great to be here at New England Law School where I see friends and colleagues. So thanks for coming this afternoon. I have to confess, this is the first time I've been invited to a business law gathering. Business law is not my field of expertise, so that just adds to the treat that it is to be here. And I'm sure I'll learn a lot and hopefully contribute a little bit too. Although what I don't know about business law could fill volumes, the relationship between theory and practice is something I've thought about for many years, in part because my position as a clinical educator has illuminated its importance to me time and time again. To come to understand what can be accomplished through clinical education, I, in a sense, had to theorize my clinical practice, which resulted, I hope, in being a better teacher. It also resulted in the publication of an article, which helped me get tenure, on the theory-practice relationship. It was early in my academic career, and I'm just remembering, as I walked in, that I still have a draft with comments from the late Professor Mary Jo Krug. And I know she meant a lot to this law school. Poignant memories. 25 years later, I'm glad to have an opportunity to revisit the topic. My views on the relationship between theory and practice have been marinating over the years. My hope is they'll provide a good general jumping off point for the rest of the conversation that we'll have today. And I think, Gary, you said speak maybe 25 minutes.
Your freedom, how you use 40 minutes.
Okay. And then hopefully we'll have time to open it up for questions and comments. When you ask about the connection between theory and practice, as this conference does, you're asking an age-old question. The categories of theory and practice have this classical vintage. There, for centuries, students of philosophy and politics and other fields have considered the nature of the interaction between theory and practice. Aristotle developed conceptions of theory and practice. And although he can be interpreted in various ways, I think it's fair to say that he saw a direct link between philosophy and politics, or in other words, theory and practice. Kant wrote an essay called Theory and Practice in 1793, in which he tried to show their necessary connections. So if philosophers and thinkers have been telling us from time immemorial that theory and practice are intimately connected, then why do we regard these concepts as such polar opposites? If we can come to understand the reasons for that, for those perceptions, then I think we'd be able to appreciate this statement that's commonly attributed to Yogi Berra. It's like, in theory, there's no difference between theory and practice, but in practice there is. And whether it's accurate to attribute that statement to Yogi Berra is another question. It's certainly a variation on a theme that's been sounded by many others over many years. But regardless of the attribution, I want to spend some time breaking down this statement to try to explore the truths that I think it captures. So to begin with the first part, in theory, there's no difference between theory and practice. That's a starting premise that views legal practice as unavoidably laden with theory. So, to elaborate that starting premise, I would observe this. In their day-to-day work, lawyers and judges, whether self-consciously or not, find themselves developing theoretical arguments and justifications. So, okay, a very simple example, not from my field, but maybe from some of yours, that if someone wants to be released from the obligations of a contract, they have to make an argument involving some kind of normative rationale or theoretical justification for why it's fair or good or right to override, in that case, the kind of standard theoretical claims about what society needs with respect to the enforcement of contract obligations. So that's a pretty modest example, I know, but even it, I think, shows that legal work that purports to be routine or purports to be practical, it's pervaded by theoretical, philosophical, and normative claims. And if you agree that that perspective describes the reality you see, then a genuine theory-practice gap is impossible. It's incoherent because law and the practice of law are inherently philosophical and normative enterprises. That's my starting point. But it's more than my starting point. It's an accurate description of my experiences in law practice and in legal education. It represents conclusions I've drawn from my experiences. The perspective that theory and practice are inescapably interconnected has emerged from my practice. It's been reinforced through my involvement in clinical education. So I want to take just a moment to discuss where the deep learning lies in clinical education and by extension then in law practice, because I think it can shed light on the theory-practice connection. In law school clinics, students are put in the role of lawyers representing clients in actual legal matters that have all the complexity that real life creates. And among other things, I think this standpoint creates rich opportunities for students not just to learn legal doctrine, but about how the legal system operates, about their own professional aspirations, about how to develop the habits that will support their continuing to learn and to grow as lawyers. And all of these are matters that are both deeply theoretical and deeply practical. In the process of teaching students who are practicing, you need to make sure that they're developing the skills to practice law competently. I suppose you can try to do that by focusing narrowly in teaching on lawyers' techniques. But in my experience, you can't teach practical competence without enacting the connection between theory and practice. So let me give a few just kind of mundane examples of what I mean by that. Let's say that in the context of a clinic case, you're trying to teach basic lawyering skills like how do you cross-examine this witness, how do you take a deposition in a matter like this, how do you choose a business entity that best fits this client's goals, how you cross-examine that witness or how you take the deposition or how you set up the entity will depend on what you're trying to achieve in that instance. It will depend on a conceptual understanding of the skills involved and how they can serve these goals. It'll depend on the theory of the case you decided on. And how will you know, say, when the cross-examination you're doing crosses the line into badgering the witness? You'll have to have some kind of normative framework that distinguishes appropriate cross-examination from inappropriate harassment of a witness. So I think all of these just very quick examples reveal that the necessary role in law practice of matters that are at least at some level of generality theoretical. So here's another pedestrian example. After you've read and understood all the law, all the precedents that are relevant to your client's case, what if the application of the law is ambiguous or unclear in the client's situation? That is an everyday problem in law practice, and resolving it requires you to develop a theoretical understanding of the rationale behind that particular law. You need to know what generated the doctrine so you can address its underlying concerns and arguments on behalf of the new case. You're going to have to characterize the precedents and say something substantive about the underlying principles. In these circumstances, that theoretical understanding of law is deeply practical. So theory-driven practice can simply look like good practice. So another example of the theoretical dimensions that law practice contains. In law practice, you want to do the right thing because it matters. There are lives at stake. There are real life issues and impacts. How do you know what the right thing is? Again, you need to consider normative theories that apply to the circumstances. So theories are required to justify practices. Theories are required to understand practices. Theories are required to guide practices to help you make decisions and choices. So these common examples from law practice, I think, can show that you can't teach competent practice without multiple interactions with theory. You can choose not to name that fact, even to yourself, but you can't avoid these theory-practice interactions. Even if a determined effort to teach skills and techniques as mechanically as possible were to succeed, I'm not sure it would succeed in teaching high-quality practice, because practicing consciously and intentionally requires conceptual clarity about what you're trying to achieve, and then enacting these broader goals by making sound choices about what to do and how to do it. Beyond that, trying to teach in a rote mechanical way undermines the clinical teaching goal of developing practice skills that can transfer to other contexts. Otherwise, they're not very useful skills if you can't use them in other situations. So transferability of skills requires a thought process about why you're making the choices you're making in this instance, the basis on which you're doing that, and the abstract features of the situation that argue for a similar approach if you encounter it in another type of case. So you can only teach lawyers technique in a mechanical way if you ignore the theoretical issues that are inherent in that situation and in the decisions and the actions that you take. Decisions and choices about actions, I think, are typically based on implicit normative principles. Just because you're ignoring the theoretical issues inherent in law practice doesn't mean law practice isn't pervaded by theoretical claims. You're just leaving these theoretical matters implicit and unspoken instead of surfacing them to inform your thinking and guide your decision making. But what this suggests to me, for our purposes today, is that theorizing should be understood as deeply practical and deeply important to the practice of law. Practicing law in an ordinary way requires legal theorizing, even when it doesn't have that self-consciousness or that ambition. It's similar to what Ronald Dworkin once called the inside-out method of doing philosophy, which starts with practical problems in the world and asks, what theoretical matters do we have to address in order to resolve these problems? I think that in many circumstances that is an apt description of the practice of law and of clinical education and sometimes of legal education more broadly. The reality is that implicit in the practice of law and therefore in the learning opportunities of clinical education and legal education more broadly are a wealth of theoretical matters, which include those related to developing perspectives on substantive justice and procedural justice. Of course, this reality creates teaching dilemmas. Which theoretical issues do you surface? How much conceptual content can you develop, and at what level of generality? But you can make these choices consciously if you have a good sense of your teaching goals, or, if you will, a theory of your teaching practice. Now, you could say at this point that I'm using the word theory too promiscuously. There are theories and there are theories. There are theories that seek to conceptualize and explain a small number of events or phenomena, at a modest or mid-level of generality. And there are theories that seek to conceptualize and explain a much broader swath of events and phenomena at a higher level of generality. My response to this is that all of these are theories. They're just theories at different levels of generality, and that multiple levels of theorizing are inherent in every situation. Just make choices about at which points you're going to focus. These situations are capable of being considered at whatever level of abstraction or generality you choose. So my point is that no matter whether you stay at the lower rungs of generality, which you might say theory of a case fits in that example, or whether you mine the practice of law for broad and profound revelations about human conflict or society or political institutions, you're doing theory and you're enacting these inevitable linkages between theory and practice. So differences between low-level theorizing and higher-level theorizing are not matters of kind in my mind. They're matters of degree. Law practice and law teaching, I think, are improved by consciously linking our theories to our actions at multiple levels and consciously using our actions and experiences to test our theories and develop our theories. That's what it means to be a thoughtful practitioner. Good theorizing leads to good practice. So I also want to say that the reverse is true. Good practice feeds good theory. Observation and experience can be used to build theory, and the theory can provide explanations of what you're observing and what you're experiencing. Observation and experience can identify flaws in a theory, exceptions to a theory, things the theory doesn't explain. That can lead to refining the theory. In other words, theory needs practice. It needs to use and incorporate contextual realities to develop and widen its application. All of that is what I mean when I say theory and practice are inseparable. Each presumes the other and each depends on the other. Theory is inherent in practice, theory is dependent on practice, theory works itself out in practice, and theory itself is a practice because it needs to be built from conscientious practices, refined through practice, and considered in light of its practical consequences. That's why in clinical education there's a strong emphasis placed on debriefing, on reflecting on practices, reflecting on experiences after they happen, so that the conceptual content those experiences contain, the theories that are inherent in them, can be extracted and made visible and available as lessons or principles for future use. If you want to think about justice, if you want to consider or develop theories about justice, one of the best ways to do that is to reflect on the empirical practice of justice as you just observed it, and to ask and examine, why did this unfold the way it did? And then sustained reflection on practice helps widen and deepen your theoretical understanding of the realities that are happening around you. One of the implications of this ongoing interactive relationship between theory and practice is that theory should be understood as provisional, not final. When experience illuminates a problem with theory, then the theory, in order to be useful to you, has to be modified. And from this perspective, theories are always works in progress. They're always evolving, they're always subject to revision, to adding more nuance, depending on what practices show us about the soundness and completeness of the theory. Now, if what I've just said at this point is largely accurate, then I think we've provided some support for the first part of Yogi Berra's observation, that in theory there's no difference between theory and practice. But how do you understand the second part? But in practice, there is. What accounts for the perception that this punchline trades on, that theory and practice, despite reasons to think they're closely interrelated concepts and activities, are still regarded as vastly different enterprises? don't have a lot of time left, but I'll try to say a few things about that. Here, we have to confront the perceptions of the relationship between theory and practice and notice that they're not innocent. They're linked with power dynamics of various kinds. And sometimes these power dynamics invest in distinguishing between theory and practice. In academia, for example, there might be professional incentives to ignore practice, to ignore theory's dependency on practice, and ignore practice's engagement with theory, although that certainly depends on the nature of the academic context. But what if what happens in practice exposes problems with the theory? What if experience and events identify some circumstances in which a theory doesn't work? One response to that situation is just to disregard these concrete events and particulars and double down on the abstract generalizations. Another response is to develop a review of the irrelevance of practice to theory and invest in the divide between them. Those responses privilege the general and neglect the particular. They privilege the abstract and overlook the concrete. If non-conforming evidence isn't considered, then the theoretical foundation can be maintained as it is. So these are defensive responses. They create and exacerbate distinctions between theory and practice instead of attending to their interrelationship, instead of perhaps revising theories to account for the new evidence. Now, I think there are like a range of hazards that follow from this defensive approach. Theories often have serious material consequences in people's lives. And just an example I've used in the past, that pre-existing theories about self-defense and criminal responsibility might not account for, say, the experience of a woman trapped in a long-term battering relationship who attacks her batterer and escapes during a lull in the violence. Without attention to the particular, and here I would add especially to the experiences of those who are not sufficiently empowered to have the prevailing theories consider them, then theory, like a theory that purports to explain the nature of self-defense, can claim a false universality. And this problem arises because abstraction divorced from practice can cover up biases. So not only is it important to good theorizing to be responsive to the particulars of the experience, it's important that the theory-building practice be widely inclusive with respect to the experiences that it consults. It's hard to theorize in a universal voice, so good theories will take steps to incorporate a broad range of perspectives in an effort to yield theory that's as comprehensive as possible. And in a radically pluralistic society like ours, that's a difficult prescription for the practice of theory. And as a result, this process understanding of theory might be resisted. Consciously or not, people may have interested reasons for rejecting the view that I'm presenting here of the inherent relationship between theory and practice. They might prefer the benefits, some of them I think quite material, that come from separating theory and practice and viewing them as different activities. Once the idea that theory and practice are distinctly different takes hold, then I think what often happens is proponents of each develop their own norms and their own cultures. And to some extent, I think that has happened in law, so that, for example, the gulf between the bar and the academy has sometimes and in some places grown and led to disdain and stereotypes and self-justifications. In my view, where that state of affairs exists, we're impoverishing both our theory and our practice. But to the extent this state of affairs exists, the second part of that old saw about the difference between theory and practice might also be true. but I'm trying to demonstrate today that I think this is based on a misperception of the fundamental theory-practice connection in the legal enterprise. In the description of today's conference that's in this program booklet that hopefully you still have, there's a, there are some questions raised. Is the teaching of legal theory in conflict with making students more practice ready? Is legal theory relevant to practitioners? By now, I hope my answer to these questions is obvious. Teaching legal theory is in no conflict with teaching students to practice law. In fact, I would say, as I'm trying to support, that legal theory is a necessary part of practicing law. And the more explicit that approach is, the better the legal practice will be. And the better the legal practice is, the better the theory and the refinements to theory that emerge from it. If legal education taught more theory and more practice, more self-consciously and in the same settings, and if in those settings legal educators clarify the relationship between theory and practice, I think it's possible that the remaining misperceptions about the so-called theory-practice gap could move and change and improve. And I see this conference as a sort of intervention into the perceived theory-practice gap. I doubt we're going to permanently bridge that gap this afternoon and all the misperceptions that created, but hopefully we'll advance our own thinking about the theory-practice relationship today. And Joanne, we have time for questions and comments?
We do. We got about 15, almost 15 minutes.
Okay. So let me close and see if anybody has comments or questions.
Just sort of a point of privilege, Attorney David Ryer. He presented 4 or 5 years ago, I think in the first conference we had. And maybe 2-3 weeks ago, I sent you an email, just essentially the title of the conference, and your response was, I practice, but I think theory is really important, and I can't replicate what you said. But I'd like to have your response to the way she was saying that the theory and practice aren't really divorceable, shall we say.
I've been practicing law for over 30 years, and I came at law with a background in philosophy, and I have always thought that I practice law best when everything I'm doing in the practice of law is imbued by legal theory. And I've observed others who do not practice law very well, that part of the reason is that they don't understand the legal theory of what they're doing. And particularly in the area of litigation, when you're practicing law, you're always thinking about persuading somebody of a legal position. You're presented with a dispute, or you're presented with parties that are in conflict, and you're looking for a resolution of that dispute. And necessarily, you have to apply some conceptual framework to it in order to think about who is right or what the proper remedy is. And once you've developed that conceptual framework, the next objective is to persuade the decision maker of your conceptual framework. And just like I always think of in philosophy, part of what makes great philosophers great is that when they write their philosophical essays, they are drawing the reader into a conceptual framework, which once the reader is drawn into it, they are bound by it, and they can't even get out of it. And they find it a very persuasive and gripping framework. And so when I practice law, especially when I'm making an argument to a judge, I'm always thinking in terms of how do I get the judge to buy into that conceptual framework. It's impossible to do that without thinking all the time about what the legal theory is behind what I'm doing, whether it's a contract dispute or a secure transaction dispute or interpretation of something in the Uniform Commercial Code, or a real estate dispute, whatever it is. And so for me, the practice of law is constantly imbued with that, and that's how I do. For me, it's 80%, 90% of what I do on a daily basis. I'm always thinking about putting things in some conceptual framework and thinking about things in that way. And there are other practitioners who they know how to write a promissory note, and they can write a mortgage, and they can or they can draft a lease. But if they get into some of them couldn't tell you what a mortgage actually is, and they couldn't even tell you what a promissory note is. And when they get into subtle areas of in a transaction where the rights of the parties are in question, they can't, because they don't have the legal theory to support the real property law that they're practicing. They're limited, what they can do. So while people can practice law with a very limited understanding of legal theory, I've found in my practice that it is those who don't understand the legal theory of what they're doing are very, very limited in their ability to accomplish objectives for their clients. Those are mine. So for me, this is an interesting topic. It fills my day every day.
Actually, as a baseline for what I'm going to ask, my background is also in philosophy. I was a physics and philosophy major, and although it was at a school that was particularly mathematical logic instead of classical philosophy, and although Rawls was one of my professors, and a pragmatist, utilitarian, but what I've found over the years actually is the question I wanted to ask is, has Myers-Briggs preferences come up in this? Because I would say that in my years of dealing with people, especially in the legal area, that maybe about 1/4 of the people in the audience when I talk is interested in history, which I love to talk about. But 3/4 of the audience is foot tapping and just giving me the bullet points. And it's just this preference that I see that I'll do the Hoffeldian stuff because I love Hofel, but the other people don't. And that's I would say that in our society and among lawyers, 3/4 couldn't care less.
And those people are wrong.
It always is a preference. It's how you get at your style of learning, what you're, for me, I always have to look at the system and make things fit in the system. That's not true for everyone.
Yeah, I think if I understand the Myers-Briggs typology correctly, the axis in Myers-Briggs that you're referring to is that NS axis.
Well, the intuitive thinkers.
Intuitive versus
like
sensei.
Right, the intuitive thinkers like to categorize.
Yeah.
Basically the sensing, basic sensing feeling people. I don't believe in atoms necessarily, but I only want to see the things I can touch and feel, empirical stuff.
Right. So yeah, the people who kind of see patterns and thrive on seeing patterns, and people who are sort of more concrete, that's what you call sensei. So it certainly conforms to probably what we all see around us, that people do have different preferences with respect to those things. But I think one of the interesting things about the Myers-Briggs typology is that even though you have certain preferences, the theory certainly allows for the idea that people can learn things that aren't their preferences. They can move toward the center. They can be exposed to things that aren't their natural inclination, things that might be hard for them, but that they can learn. So I think since that theory allows for it, that we don't necessarily have to simply play to preferences or simply, gather the subset of people for whom this is their preference. I actually think it, because it is sort of pervasive and these theoretical implications of everything we're doing in the day-to-day practice of law, I think we can sort of help to expose that, even though it might be more the cup of tea of some than others.
Yeah, the two women who were Myers-Briggs back early on, sold their wares to the Hayes consulting company to basically, but it's not a theory, it's just a preference. And it's a way, I guess in artificial intelligence today, you may do clustering. And you know, how much confirmation bias, I don't know. But I was just curious whether in any literature in this area that's been looked at.
Like a lot of things, I think the literature is kind of specialized. I haven't seen the merger of theory practice literature with Myers-Briggs per se, but I think the way you're bringing them together makes sense, and probably explains what we see in a classroom context too, with respect to those who are very kind of automatically inclined toward looking at the conceptual content of the particular matters we're addressing, and those who might need more encouragement to do that. Yeah.
Less a question than more of an observation, but at least when you talked about the business side of it, there's some interesting, I think, current things where I'm thinking of Citizens United, Hobby Lobby, and the Masterpiece Cake case that's coming up. We have a discussion next week on that, where really, I think there's a lot of out-of-the-box thinking about what a corporation is, what kind of rights a corporation is, what kind of rights does the corporation reflect the rights of its closely held members. It's really an interesting example, I think.
And how does it intersect with what kind of democracy we want to have?
Right.
And again, I don't think you can't talk about Citizens United. You can talk about the doctrine. You can talk in very practical terms about, you know, how those cases might proceed. But again, inevitably, there are large, socially important questions that are there for the taking as well. And you can choose to ignore them. I actually think you'll do better thinking about the case and ways you might proceed in the case if you don't ignore them.
Isn't there a moral dimension to theory? And I notice your background is largely in criminal law. I've taught both contracts and criminal law. In contracts, teaching contracts theory is a lot of fun. Well, more for the professors and the students. But in criminal law, it's absolutely essential. I mean, what business do we have putting people in jail for years for possession of drugs if we don't have a theory as to why that's good for society and maybe good for them? And you've got to teach theory because you shouldn't be putting people out into the criminal courts if you don't have it.
Yeah, and I do think so many of the concepts in the criminal law area are profoundly philosophical. Yes, they're about the kind of society we want to have and the role of blame and punishment in society, but you know, the nature of criminal responsibility. What does it mean to hold somebody responsible, and what about instances of mental illness? How do you think about a confession which needs to be voluntary in order to be admissible? What is voluntariness in the context of police custodial interrogation? And those are, and often litigating those cases involves the development of those perspectives, kind of explanations of how this can't possibly be what voluntariness means in this situation, because here's what we know about what it means to do something voluntarily, and here are the features of this situation. And so again, yes, it's broad, it's general, it's abstract, it's conceptual, but it's deeply connected to the practice of law. It's deeply connected to the facts on the ground. And the more we kind of make that connection obvious, I think, the better our theory will be and the better our practice will be at one and the same time.
I'm sorry. No, I can wait.
You can do one more.
I was Fascinating. The one part of your talk that focused on the question of bias and how theory can kind of obfuscate some of the biases or maybe cover over some of the biases. I was thinking about, what do we mean by theory? And I heard a lot of what you were talking about as normative judgment as equaling theory. And I think that part of this is nomenclature. If we can think of it more as normative and less as theory, we might be able to get quicker. It might be easier to get to those biases. I was thinking of Paul Butler's article on the critique of rights with Gideon versus Wainwright, and whether or not the Sixth Amendment right to counsel has actually made things worse for criminal defendants, not better. And I wonder if we stop thinking about it as theory and start thinking about it as normative decision-making, we might be able to kind of crack that nut a little bit faster.
Yeah, I think it's possible. I mean, I tend to see normative theory as one species of theory. I tend to put it in that box, but I can see what you're suggesting with respect to kind of separating. Everybody makes judgments about what's right to do here. So maybe that's something. It's more in people's common experience to think about making good judgments normatively that makes it easier for some to swallow.
Better wipe this one. Thank you so much.
Sure.
Now I'm going to interject. Ms. Burnside? Hey. Ms. Burnside? What? You have to sign? I'm going to send you off to get some of your friends. Extra credit. Get some friends. They're not getting the enrichment they need. I wanted to thank you very, very much. And I just wanted to make mention, Professor Goldfarb has written some really interesting things. One of the joys of working on a conference like this is reading the articles of some of the participants. I read 2 really excellent articles on death penalty jurisprudence. And I know she's taught a course on death penalty jurisprudence. There's a very recent article, however, from the Nevada Law Journal, summer 2017, that's an article of a different sort. And after I just sort of gently suggested that this might be a nice article to make available, it's really about the 14th Amendment. And I think what might have been the law under the 14th Amendment, but for, shall we say, certain theories about constitutional jurisprudence which constrain so much the development of the 14th Amendment. It's a really nice article. It's called Equality Writ Large, and I left a few copies on the table to the right, should anybody have an interest in that. So, thank you very much. I want to now introduce my friend, longtime friend, Kurt Nyquist. This article he has published to go to your American law. Kurt. Yeah, may I distribute those now? Would that be helpful?
Yeah, because I'm going to refer to it. I got
You want to take half of them, and I'll take half of them, and we'll refer to those things?
So
So, Phyllis, thank you for mentioning Mary Jo Fruit. Her imprint is on this school, literally on this space, that one of her assignments at New England was to chair the library committee when the committee was trying to rethink, reformulate our library. And the thing she kept in mind, uppermost, was creating space for the people who work in the library. I see several of them here. So thank you for mentioning her. Let's talk later about Mary Jo. And the first word in this article, reread, is in tribute to Mary Jo. She published an article in 1985, Rereading Contract Law, a feminist analysis of the contract casebook. So I very intentionally used that rereading word, and first word in the title. She really was a mentor to me in contract law. If I know anything about theory, it was in large part because Mary Jo and I talked extensively about theory. And Gary, thank you for organizing this conference and for your kind introduction and for inviting me to participate. I'm honored to be included. Now, I'm going to be commenting on this rereading article. Make sure you have a copy or have access to a copy, because I'm going to refer to it a couple of times. This version you have is not the final edit. It's for our use today. If you're interested in citing or quoting the article, make sure you use the published version, which will come out in a few weeks, in volume 65 of Buffalo Law Review. I also want to thank Gary and Peter Carroll for being two of my readers. They saved me from many errors. My plan is to summarize the article in about 20 or 25 minutes and leave the rest of the time for questions and comments. And I hope to encourage at least some of you to read the article, and if you do, let me know if you find it persuasive. If not, why not? I would love to hear your reactions. And I want to enter a plea that our definition of theory includes a sense of the history of American legal thought. As Oliver Wendell Holmes said, the rational study of law is still to a large extent the study of history. History must be part of the study, because without it we cannot know the precise scope of rules, which is our business to know. It is part of the rational study because it is the first step toward enlightened skepticism, that is, toward a deliberate reconsideration of the worth of these rules. When you get the dragon out of Samuel Willis produced the first law school case book in contracts, and then 10 years later published a guide to contracts explaining the proper interpretation of the cases. Holmes delivered the common law lectures in the fall of 1880, and they were published the following spring. By the way, the location of Holmes's lectures is within a few blocks of us. It was on the campus at MIT, which was in Boston at the time. And the Holmes lectures were a big deal. It was a ticketed event. The Harvard Law School Archives has 2 tickets in its collection. They were in one of the front rows, on the aisle. I'm guessing they were Langdell's tickets. At the time, Holmes was seeking a faculty appointment to Harvard, and he wanted to ensure Langdell would have a clear view of his brilliance. Now, Holmes is interesting for many reasons, not the least of which is that he lived forever. 2 people he knew or met in his lifetime were John Quincy Adams and Alger Hiss. Adams would visit Holmes Sr., and while Holmes Jr. was running around, and Alger Hiss was one of Holmes's Supreme Court clerks. So applying the theory of overlapping lives, Holmes spans almost the entire history of the Republic, and his views on law changed profoundly. His work was influential as a reflection of classical legal thought in the common law lectures, and then he was also a significant precursor of legal realism. Privilege, Malice, and Intent from 1894 signals a radical change in his thought. The third contributor, Williston, filled in much of the detail of the theory in his scholarship and Sale of Goods casebook. Now, classical legal thought provided a complete framework for understanding law. Private law was separated from public. It was rules-based, as contrasted with standards, based on individualism as an organizational scheme for society, as contrasted with altruism, and the rules system was constructed by a combination of induction and deduction. Langdell saw himself as a legal scientist, and the science he argued we should study was the science of legal categories. In his view, the legal scientist chooses the important cases from the vast array of cases. He says most cases are useless for the purpose of constructing the system. Once you century. '20s and '30s. Mort Horowitz, for example, says progressive jurisprudence and legal realism should be understood as subcategories of pre- and post-World War I progressive legal thought. And legal realism needs to be seen primarily as a continuation of the reformist attack on classical legal thought. But there's also a deep sense of concern about our understanding of legal realism. Neil Duxbury says, realism, quite simply, remains as elusive as it has been influential. Now, the origins of my article are found in a sentence from a Duncan Kennedy work where he says, I depart from current fashion by treating legal realism as the critical devastation of sociological jurisprudence, that's his word for the progressives, rather than as extension of the sociological jurisprudence critique of classical legal thought. Duncan's a wonderful wordsmith. I depart from current fashion. I wish I had said that. And I asked him about this sentence, and he said, well, this was his intuition, but it was clear he wasn't going to write about it in any detail. He's been busy doing other things. I decided to undertake the project, and if ever there were an educated guess, this was it. As I read the progressive and realist literature, it became clear to me that he was correct. Although the realists continued to attack classical legal thought, what makes their work interesting and important is their critique of the progressives. So that's the first idea at work in this article. But in the process of reading the literature, I noticed several other aspects of the realist era that I hadn't seen before. There was a cognitive relativism at work, and it was derived from science, mathematics, psychology, and the arts that made the era completely different from any prior era. Law even has its own Heisenberg uncertainty principle moment. Leon Green's The Negligence Issue, 1928 article published in the Yale Law Journal. I'll talk about that in a minute. Secondly, my article offers a genealogy of balancing. With the discrediting of formalism, balancing became the default mechanism of legal analysis. Throughout the progressive and realist eras, there was a constant discussion of balancing, but I found it confusing and contradictory until I finally realized there were two radically different types of balancing in play. Unfortunately, both sides use the same language, balancing, weighing of interest, and so on. I think there's still confusion and uncertainty about balancing generally. So one of the goals of the article is to try to bring some clarity to that issue. And the final idea is to comment on responsible decision-making, whether it's a legal decision by a judge or the type of moral and ethical decisions we make every day. When I taught at Warwick Law School, my office was next to the philosophy department, and the chair of the department, David Wood, invited me to participate in department events. One of the events was a seminar in continental philosophy. It was for graduate students. You know, a lot of it was beyond me. But one day, he made a comment that drives the last part of this article. He said, responsibility. What does that mean? Fundamentally, it means the ability to respond. So that's the question I asked in the final section of the article. What does it mean to have the ability to respond in making moral and legal decisions? Martha Nussbaum and Joe Singer have important things to say on that issue. So here's a quick summary of the progressives' critique of classical legal thought. Roscoe Pound's pre-1910 article set out the parameters. He says things like, for the first time, the common law finds itself arrayed against the people. It exhibits too great a respect for the individual, too little respect for the needs of society. Law should be based on the study of social conditions. Pound coined the phrase sociological jurisprudence and describes it as a movement for pragmatism as a philosophy of law. In this era, he spent time in Chicago, and he came to know Jane Addams, the founder of Hull House. Hull House worked with immigrant communities, providing support in education, housing, and employment. Pound delivered lectures at Hull House, served on its juvenile court committee, and I think his experience deepened his appreciation for the wide scope. Based on 5 ideas. Viewed fact. It was unwilling to examine its postulates, and in attempting to derive law from studying society, it fell into the same conceptualist error as classical legal thought. Now, the critique was intertwined with and based on a cognitive relativism. The realists found in psychology, physics, math, chemistry, and geometry. Pound had no doubt it was the progressives the realists were attacking. He wrote in 1938, "Today, rationalism is under attack from another quarter. A psychological realism is abroad which regards reason as affording no more than a cover of illusion for processes judicial and administrative that are fundamentally and necessarily unrational." Now, the realist rule skepticism is often discussed, but the point here is that the attack included both classical legal thought and the progressives. The realists thought the progressives fell into the error of believing they could confidently categorize, manipulate, and deploy law. Pound, for example, divides statements of law into 2 types, rules and standards. He says rules are appropriate for conveyances of land, inheritance and succession, commercial law. Standards are appropriate for the social interest of individual self-assertion. This is term for that. In an article from 1928, Leon Green takes a nihilistic view of standards. In a negligence case, the pertinent factors are beyond classification and statement. The combination of factors are literally infinite as time and space. Juries consider an array of factors not expressed in the standards. How a jury reaches its conclusion is perhaps unknown even to themselves. The law recites its ritual and stops. The law of negligence defies the efforts of legal scientists to bring it under more definite control. Close quote. In the next few years, the realists would extend the critique to all law, standards as well as rules. This is the Heisenberg moment in American legal thought. Now, the Heisenberg Principle is you can measure the speed of a subatomic particle or you can measure its position, but you can't measure both. In the classical picture of the world as a great machine, it had been assumed that the parts of the machinery could be defined with limitless precision. Heisenberg was saying you couldn't always find out what you wanted to know. And if you couldn't describe the natural world as you wished, how could you ever hope to reason out its laws? Now, let me interject here. There was tremendous interest in the realist era in the sciences and mathematics. Walter Wheeler Cook, for example, before he turned to law, had been an assistant professor of math at Columbia and also held a traveling fellowship in physics, which allowed him to spend 2 years in Germany. Math and physics provided a foundation for his critique of the progressive era. He published an article in 1927 in the Journal of the American Bar Association where he summarized recent developments in science, the abandonment of the doctrines of conservation of mass, of matter, and of energy, quantum theory, all these and others, Cook says, have left modern physical science gasping for breath. He quotes a mathematician, Cassius Kaiser, "The old cosmic absolutes are gone. The reign of relativity is destined to work a corresponding revolution, deep, noiseless it may be, in all the views and institutions of man." Cook then attacks Pound and legal education generally for teaching the traditional and known technique of the common law, which is grossly inadequate for legal purpose as the child's mechanical notions of the 19th century have shown themselves in physics. Another realist, Jerome Frank, developed a deep interest in psychology that provided a lifetime trajectory for his work. Even the titles of many articles betray their interest in science. Mr. Justice Holmes and Non-Euclidean Thinking, Scientific Method in the Law, and on and on and on. Several of the realists combined rule skepticism with fact skepticism. Jerome Frank argued that not only juries, but judges are unable to assess facts with certainty, as a judge is a fallible and variable witness of the witnesses. He accuses Cardozo of appellate court-itis since he spent most of his days in the relatively placid that was a historical final critique founded either on a study of society or a legal scientist's intuition about a policy goal. Holfeld, for example, in an article from 1917, discusses the negotiability principle, the power of a transferor to deliver a better interest to the transferee than her own. He says, such powers are created on various grounds of policy, the teleology underlying each particular instance not being difficult to discover. He cites sale of goods and market over, power even of a thief in possession of money to transfer a good title to a bona fide purchaser. And then he says, these cases depend on the public policy of securing freedom of alienation and circulation of property in the business world. Now, the critique by the realists is that the progressives completely ignored the counter policies. Protection of the purchaser in a negotiability case is in direct conflict with the counter policy of protecting the original owner. Where the progressives saw one policy leading to a legal principle in a one-on-one way, the realists saw policies in conflict. Now, one of the puzzles in American legal thought is how the realists, with their profound skepticism, could continue to serve on law faculties, be appointed as judges, or work in administrative agencies applying legal principles. Best answer I could find is in an exchange of letters between Felix Frankfurter and Jerome Frank. Frankfurter had written saying that in his view Frank was wrong in thinking most of the law is bunk. Frank replied, I don't say that most law is bunk. Do you remember the farmer who was asked if he believed in baptism and who replied, believe in it? Hell, I've seen it. I think law is damned real, but I believe it does not work in the way that it appears on the surface to work. Now, throughout the progressive and realist eras, there were frequent references to balancing. So look at the first two quotations. This is on page 1. First is from Roscoe Pound. Last sentence, this is a mantra he created and used for more than 40 years. To seek to satisfy the most they might with the least sacrifice. Felix Cohen, second quotation. Dean Pound has taught for many years of the balancing of interest, but he never indicates which interests are more important or how a standard or weight of fitness can be constructed for the appraisal of interest. So I think there are two types of balancing in play in the realist era. And there are charts on page, 57 and 58 that attempt to explain this. So on 57, that attempts to explain teleological balancing, and that was the progressive's view of balancing. You have two policies. They're on opposite ends of this force field, but notice they have influence in the force field. The line in the middle would be some statement of law about, let's use holder in due course as an example in Article 3, that a holder in due course takes free of personal defenses. If you're not a holder in due course, you take subject to defenses. So if the plus is the holder in due course policies and the negative are the policies to protect the original party, they can raise the defense if the widgets are defective. Each of the conflicting interests only operate up to the dividing line, and the dividing line is the rule in Article 3 of the UCC. That's teleological balancing. It seems to me that it's very easy to slip into formalism, taking a teleological balancing approach. Conflicting considerations on page 58, that's the view of policy I believe in, frankly. You have these two policies, but they each operate throughout the field, so that and a court has to decide in a particular case, well, we think the holder in due course here will win, so we're going to position the case to the right side of the line. But that inflicts harm on somebody, the person who has the defense. Now they have to pay for the defective widgets. It seems like a simple difference, but I think it actually has profound consequences. So first you have these two ideas of balancing at work in the realist art era. And what I tried to do was to create a genealogy of balancing. It's not a history, it's a genealogy. So what's a genealogy of balancing? It's fragments being collected together later to be used to construct a theory. It's kind of bricolage in terms of art. This is not linear. I couldn't find an article that says, well, this is this origin of this idea of balancing, and I couldn't follow it through subsequent articles. That would be writing a history of balancing. This is not a history, it's a genealogy, and I think the fragments of these two approaches to balancing are created in the realist era in this argument back and forth about what balancing means. Okay, so then the last part of the article is the concept of ethical and legal decision making. So looking at this chart again on 58, let's imagine the positives and the negatives are two moral forces at work, moral forces in conflict. Now, here I'm drawing heavily on the work of Martha Nussbaum. Socrates argued that the idea of competing moral claims is illogical. So he would say the first force field is the one that's persuasive. In a Manukan system, it's part of the very notion of a moral rule or principle that it can never conflict with another. They would say at force field B, that's wrong. Each of the moral principles can only operate up to the line. Force field A is correct. And almost the entire history of philosophy said this. Now, Martha Nussbaum writes about an insight from Greek tragedy that life often offers choices where even a good person has no alternative but to inflict harm. And chart B pictures this. In law, competing policies each operate throughout the field, and to decide for one of the other parties is to inflict harm on the other side. Now here's her example from Greek tragedy. She used the story of Agamemnon. He's sailing to Troy, and the fleet is becalmed, and he learns in a prophetic utterance that the winds will not return unless he sacrifices his daughter. At first he is horrified at the thought, but then he decides that yes, that's the better decision under the circumstances. The chorus criticizes him not for the decision, but for his attitude toward the decision. He displays neither regret nor remorse. He does not struggle against it, but becomes a willing collaborator. He separates himself from the decision, saying, it's not my decision. Forces have imposed this on me. Now, Joe Singer has a wonderful summary of the idea of responsible decision-making, both legal and moral. The better response is to recognize the conflicting claims, to feel them pressing upon you at the moment that you act. The realists have a very clear view of the consequences of a conflicting considerations view of policy for judges. And final comment, David Wood published a book called A Step Back. He argues that when concepts become too familiar, we lose the ability to think about them. We reduce them to something that we've known all along. He quotes Wittgenstein, we want to walk, so we need friction, back to the rough ground. As applied to law, Pound, for example, always knew what to say about balancing. He had stopped thinking about it for the last 40 years of his life. David Wood participated in a 3-week colloquium on Heidegger, and Wood says, we tried to make sense of this particular book, And it would be fair to say we're trying not to make sense of it, trying to keep it at a certain distance, trying to allow it to continue to work on us. And I think the ultimate goal of my article is to encourage us to take a step back from the conventional accounts of the history of American legal thought and to balance it so that we can think about them in a new way. Thank you for your kind attention.
That's an article, I think, that's for the ages. There's an awful lot there. That's not going to be something that's just going to gather dust. And that's why I'm holding up this 5 minutes. Because, Ann, we're not going to cut into your time. We'll extend it a teeny bit. The group is so big that we can't do that. Because I think people should get a little bit of time. If you have a question, somebody want to comment? Okay. Yes.
Yeah, would you say Agamemnon made that decision for the greater good of his people, for the Greeks? That's why he chose to essentially sacrifice Hellas, right?
Right, but he had no choice to inflict harm on someone. Right, it's either going to be the daughter or the entire fleet. So the chorus doesn't criticize him for the decision. It's his attitude toward the decision. And we've all been in court where a judge makes a decision, they wash their hands of the consequences. Joe Singer's point is that the judge should really engage with the moral consequences of the decision. Right at the end of the article, maybe we'll finish with this. Last page. There's a quote from state court judge in Colorado, Leland Anderson. It's on page 77. And he was on the bench for 10 years. And during that time, in a capital case, judges would vote on the death penalty. There were 3 judges who voted. And he reflected on that experience. He said, these cases continue to haunt me, even to this day, many years after having signed off on them with a trembling heart. In the interim, I have struggled emotionally and morally with the issue of the death penalty. I know these decisions remain with one the rest of one's life. This is a wounding experience. I think Oliver Wendell Holmes would agree with Judge Anderson's view of judgment. It can be a wounding experience. You can't distance yourself from the consequences of your decision.
And I'll ask Kurt a question here. First, I'll remind folks that articles about, and I think a couple articles from Wesley Newton Holfeld are on the table to the left over there.
Correct.
If somebody has that interest, I know Attorney Steve Chowsick would like Holfeld, I think so. Help yourself. We wanted to make these things available for anybody teaching. Now, the thing I'd like to ask you to comment on is, you asked that we, from the common law tradition by Carl Llewellyn, we have available his canons. Mm-hmm. So comment on that. They're available also, very briefly, because I want Professor Antoine to get started.
Those of us who have spent much of our lives in the Uniform Commercial Code, the 2 great gods are Carl Llewellyn, chief reporter of the UCC's project, and Soya Menchikov, associate chief reporter. They would agree with the first part of the statement from Yogi Berra, that there's really no difference. In selling the UCC project, Llewellyn had the respect of the academic community, and Menchikov had the respect of the practicing bar, particularly in New York. But they both worked both sides of the street. Llewellyn, early in his career, would go to banks, and he would say, now, if I were a check being presented to your bank, what would happen? And he wanted to go down into the bowels to see how checks were actually processed. So he had incredible interest in the actual detail of cashing checks. And Menchikov, of course, a great lawyer, but also her work in contract law is incredibly theoretical. Now, this is Canons on Statutes, which I used in every one of my classes, I think. This is a Llewellyn piece collecting I think it's 28 pro and con arguments. It's like he's read 1,000 cases, and the court will say, well, the plaintiff has to win because of the plain meaning doctrine. That happens in 42 cases. But then in 53 cases, it says, no, we're going to ignore the plain meaning because there's an important policy at work here. So this is like the Philosopher's Stone, I think, because, it collects up these 28 pro and con arguments. And I've had a couple of times graduates contact me, and they said, I've lost the article by Llewellyn that you gave me. And I've used it for 15 years, and now I can't find it. Well, I'll send you another copy. So this really breaks down the divide between theory and practice. I guess one of the points is this is a canon. These are the acceptable arguments. And one of the experiences of first-year law students is they trot out an argument. It seems good to them, but it's not acceptable in the canon. Right? You notice none of these are, well, the plaintiff should win just because it's not part of the canon. And the canon can expand and contract. Law and economics arguments came along much later than this piece, and at first I think a lot of lawyers didn't know what the heck was being said in court because it was not yet part of the canon, but those arguments worked their way in. And then I think the rest of the canon gets reshuffled somehow when you have a new argument all of a sudden arriving. So that's my comment on that canon. Thank you.
This is such a fascinating article.
Oh, thank you.
I really, just from, in the course of listening to your remarks, I just, this re-periodization of this period of time is so interesting. But I wondered whether, so the article frames realism as primarily a critique of progressive thought, but in several of the sources that you cite several of the sources that you cite that are developing the realist critique, the time period in which those ideas are stated predate the full flowering of progressive thought and seem to be addressed primarily to the classical legal jurisprudence that dominated the court until the post-Lochner, until just after Lochner. So I just wondered how, just methodologically, when did the shift occur from realists addressing themselves to the extant constitutional jurisprudence of the time to the realists addressing themselves to the progressive critique of the extant constitution?
I think they're both going on at the same time. And the critique of classical legal thought, Pound had pretty much demolished classical legal thought before 1910. His work is really wonderful early in his career. Then he just kind of goes haywire later on. But so they continued the critique. But to me, that wasn't so interesting because the critique had already been established. What was interesting is the realist critiquing the progressives. So it's and I divide the eras, which is totally arbitrary. 1923 to 1941. I just picked a couple of dates that seemed to make sense to me. But one of the points is that the world of 1930 was dramatically different from the world of 1910. So that's why I broke that into two eras. There's been a lot of ink wasted trying to figure out who was a realist and who was not a realist. I think that's just wasted time. What is interesting is this cognitive relativism, derived from the sciences, literature, that's at work in the realists, and that helps them critique the progressives. So what's important about the realists to me is their critique of the progressives, not their continuing critique of classical legal thought, which they also did, but it's intertwined, it seems to me, in the realist era.
I want to, and I thank you, I want to move on to Professor Ann Fleming. I've got to cut your time a little bit, but we'll also extend it into the break time a little bit. I know we could continue on a lot more with questions for Professor Nyquist, but in fairness, I want to do that. I want to introduce Professor Ann Fleming from Georgetown University Law Center. We were looking for someone to follow Professor Nyquist, and I literally went to the AALS section, made some calls. She graciously accepted an invitation. She's done a lot of fine writing, and there's one article in particular that I thought was very intriguing, The Rise and Fall of Unconscionability as the Law of the Poor. Almost everyone has read Williams versus Walker Thomas Furniture Company. It's a really interesting behind-the-scenes article, and that's available. Now, just before you start, I also want to recognize Professor Steve McJohn, co-author of the Whaley McJohn series, writes a delightful study aid on commercial law, has come over and taught 4A for me, and was a presenter 2 years ago. Thank you.
Great. So I'm excited to be here, and I want to start off with kind of returning to a question that was brought up during Professor Goldfarb's Q&A, which was the difference between types of theory. So the advertisement for this conference explains legal theory has really two sides. Legal theory can be thought of as a lens to engage in thinking not only about how the law currently works, but also as part of a values-driven inquiry into how the law should work. Right? So we might think of those as really two types of legal theory that sometimes combine and can overlap, but descriptive or prescriptive theory, descriptive theory and prescriptive theory are really two different categories, right? So descriptive theory, sometimes called positive theory, helps us think about how the law is, how the law actually works, and prescriptive theory or normative theory helps us think about how the law should work, the value-driven inquiry part of the description. So what I want to really focus on is descriptive or positive legal theory, meaning theories that help us think about how the law actually works in practice. And I'm using theory in kind of a broad way to mean some insight about how law or legal institutions work that is somewhat abstract, meaning that the insight is generalizable beyond just the specific set of circumstances that it's describing, that it can be applied elsewhere to think about how law or legal institutions work. So a theory might explain how all the doctrines of contract law fit together, or how law develops over time, how we arrive at our current set of rules. Or it might describe the likely effects of adopting a particular rule and the incentives that it would create for different parties. So a major question for us to consider is there really this tension between theory and practice? And I think, like everyone probably speaking today, I would say no, that theory and practice should reinforce each other. That descriptive theory, divorced from the reality of legal practice, is just not very good theory. Good descriptive theory starts with observing how the law works, and then uses that evidence or data to then derive some more generalized conclusion that rests on a strong empirical foundation. And bad theories, on the other hand, just ignore evidence or data that run counter to the theory. So the best descriptive theory is based on watching the law in action and then using that knowledge to construct a theory about how the law works in more generalized terms. So it's very hard to be a good legal theorist without engaging with the reality of legal practice. And it's certainly, the flip side is it possible to be a good practitioner without engaging in legal theory? And certainly you can practice law without engaging in legal theory, but I think theory can really enrich practice because it helps the practitioner make sense of the world that we encounter. And in fact, as I believe Professor Goldfarb said, most lawyers have theories about how the law works. Those theories can derive from law school, they can derive from real-world experience, but human beings, I think in general, lawyers and non-lawyers, when we observe the world, we tell ourselves stories to make sense of that world that we see. And each story then supports a different theory about how the law works in practice. So, for example, we might notice that a lot of the unconscionability cases from the contracts casebooks are from the 1960s and 70s, and a lot of them involve poor people buying stuff on credit. So based on that observation, we could tell a few different stories about why that is, why there was this sort of sudden flowering of the doctrine of unconscionability in the 1960s and 70s involving poor people. And then depending on what story we pick, that will then lend support to a different theory about how law works. And so part of the aim of my work is to test these theories and test these stories to see if they're really supported by the facts on the ground. And then also to gather facts and try to generate new theories about how the law works. So to make that a little bit more concrete, I want to use a couple examples from my work, in part and drawing on the unconscionability article, to show more specifically what I mean and also how those observations, those theoretical observations, might be of value to someone in legal practice. So my research is focused on the development and regulation of small sum lenders, so the precursors to today's payday lenders, rent-to-own stores, pawn shops, starting in the early 20th century and continuing through the present. And one chapter in that history is about the role of unconscionability litigation in policing lending to the poor. So we know, as I mentioned, that there was this flowering of unconscionability in the 1960s, and even today many lawyers are introduced to the doctrine of unconscionability through these cases from the 60s and early 70s. But we could tell different stories about why that is. So one story to make sense of this sudden appearance of unconscionability and then sort of quick fading away of unconscionability in cases involving poor litigants buying stuff on credit is that this revival of unconscionability was the work of a generation of activist judges who decided they were going to rewrite consumer contracts according to their own sense of justice. But in fact, judges ended up hurting the very people they were trying to help. Unconscionability backfired, it became unpopular, it faded away. And so this story that we could tell about what happened would support a particular theory about litigation, about how law works in practice. So from that version of the story, we might conclude that granting discretion to common law courts to do justice by reviewing contracts after the fact backfires. It leads to undesirable outcomes. It hurts the people that we're trying to help. We should instead leave it to the political branches, to legislators, to try to devise rules that make sense for policing boilerplate in consumer contracts. Okay? So that story is slightly different from the story that I uncovered in going through the records related to the Williams case. So my story is that rather than the courts going off in one direction and the legislature going off in another, that in fact legislatures and courts were on the same page when it came to policing boilerplate in consumer contracts. So state legislatures lay the groundwork for the flowering of unconscionability in the mid-1960s, and then legislative activity accounts for the declining number of unconscionability decisions in the decades that follow in the 80s and 90s. And my main evidence for this, which I'll lay out in a bit more detail, comes from looking behind the scenes of the Williams v. Walker Thomas case. So as you may recall if you read Williams in law school, or perhaps you teach Williams, so Williams is a poor mother who lives in Washington, D.C., who had bought some household goods on credit from a local furniture store, Walker Thomas, over the course of about 5 years. After she defaults, when her debts are nearly paid off, the furniture store claims the right to then, under the terms of the installment sales contract, to repossess everything that she had purchased over the course of 5 years. So then the case works its way up to the D.C. Circuit. In 1965, Judge Skelly Wright writes this, what becomes a famous opinion in the case, declaring that the Williams contract was potentially unconscionable and remanding the case for further findings by the trial court. So Williams has generated an outpouring of scholarship, but none of this work had really looked at what was going on beyond just the published decision. So that's where I started digging. And what I found is that the congressional enactment of the UCC for the District of Columbia really laid the groundwork for the unconscionability claim that is then asserted in the Williams litigation. And that the Williams litigation then, in turn, catalyzed this process of legislative change in the district, that the litigation raised public consciousness about problems that were going on in the marketplace for household goods, and fueled a drive for substantive reforms through statute. So in response to urging from consumer activists, from local lawyers, Congress eventually adopts a new set of bright-line rules to govern installment sales in the District of Columbia, and they ban the use of this pro rata term that appeared in the Williams contract. So in other words, my story is the legislature doesn't override the misguided courts. In fact, the court and the legislature are working together towards the same end. So from this story, we might derive a different theory about how unconscionability, and really more generally about how litigation works in practice. So from this story, we might say, granting discretion to common law courts to do justice by reviewing contracts after the fact can actually have positive effects for poor consumers. That in fact, we don't need to choose between litigation and legislation as a means of bringing about legal change. In fact, litigation can prompt a legislative response, just as it did in the Williams case. So let me lay out my evidence in support of that in a little bit more detail, and then come back to how I think this has implications for legal practice. So the rise of unconscionability. Why does unconscionability suddenly appear on the scene in the 1960s? What sparks this revival? So I argue it had everything to do with legislation, with the Uniform Commercial Code. Now, Williams, some of you may recall, was not actually decided under the Uniform Commercial Code, but in Williams, Judge Wright says that unconscionability is part of the common law of the District of Columbia. But I think that the timing of that decision and the general kind of rediscovery of unconscionability as a part of the common law had everything to do with statute, with the UCC. So unconscionability, if we look at the record of the case as it worked its way through the court system, unconscionability is not on the radar of anyone involved in the Williams litigation until the District of Columbia adopts the UCC at the very end of 1963. So we can see this very clearly in the Williams case record when this discovery of unconscionability occurred. So Williams doesn't raise unconscionability at trial, doesn't raise it in her initial appeal. It is raised for the first time before the DC Circuit, and this is largely because of very lucky timing for Ms. Williams. So Congress adopts the UCC for the District of Columbia right before Williams submits a request for review to the DC Circuit, which at that time was reviewing decisions by DC state courts. And so Williams raises the newly enacted UCC unconscionability provision in her petition for review, which seems to have caught the attention of the judges of the DC Circuit. And then after that happens, very suddenly the case is all about unconscionability. So the DC Circuit not only grants the petition for review that she files, but also appoints a local lawyer to act as an amicus in the case. And the amicus brief also ends up focusing almost exclusively on unconscionability. So it's as a result of this chain of events that began with an act of legislation that at the very 11th hour of this litigation, unconscionability becomes a major issue in the case. And we now know the famous majority opinion written by Judge Wright relies pretty much solely on unconscionability in order to reverse the decision in favor of Walker Thomas and send the case back to the trial court. And Wright believed at the time that unconscionability was going to be a game changer. That this was going to be a really significant doctrine. And he wrote in a letter in 1967, described Williams and unconscionability as part of a, quote, growing area of the law of the poor. And he predicted that unconscionability would be, quote, very helpful to those who are working in this field. And in fact, there was this burst of unconscionability litigation in the late 1960s and early 1970s involving poor consumers. But then after that, the number of cases kind of drops off. And the question is why? Why doesn't unconscionability have more staying power? Was Judge Wright incorrect? Was the Williams litigation ultimately useless for poor people? Did courts really just end up hurting the people they were trying to help? So my argument is that Williams did matter, that it did help change the rules that govern poor people's consumer contracts, but that this didn't happen in the way that Judge Wright probably thought that it would. So for Ms. Williams herself, the case ends in a settlement. The case gets remanded, the parties settle. The trial judge never actually decides whether this specific contract is unconscionable. But the impact of the litigation doesn't stop there, the broader impact. So what I found is that this sounded an alarm among the sort of DC legal community, those who are interested in these types of contracts. So it alerts DC consumer advocates and, by extension, lawmakers to this recurring problem that's in need of a more permanent legislative fix. And so after the initial appeal in the Williams case, a committee of concerned local lawyers and activists formed. They set to work drafting consumer credit regulatory legislation. And we can see references to Williams, to the Orally Williams situation recur throughout the congressional debates over this legislation. And so Congress in 1971 eventually passes a new set of rules to govern installment sales in DC, and this law explicitly bans the contract term that was at issue in the Williams case. So as a result, by the early 1970s, in the district, poor people's consumer contracts are sort of partially carved out of the common law of contracts. Some terms are shifted towards being regulated by statute, and the statute specifies that certain terms are allowed and certain terms are banned. And so as a result, the future Ms. Williamses of the world don't need to bring unconscionability claims because there's a bright line statutory rule that says this specific practice is not allowed. So what are the sort of broader theoretical insights that we can derive from this evidence that might be of value in thinking about how litigation works and how unconscionability works? So I think at minimum, we have to revise the story that we might tell ourselves about unconscionability. So this existing narrative, which we often tell first-year law students, drawing on a lot of law and economics scholarship, is that unconscionability is really a dangerous doctrine. That reviewing bargains after the fact can end up backfiring, it can hurt the very people that we want to help. We should really leave policing consumer contracts to the legislature or to the market rather than using this doctrine to kind of do justice after the fact. But I think that that story, although there may be some truth to that, ends too soon and focuses too narrowly on the outcome of a single case. So if we think of the Williams litigation in sort of the longer time span, we can think of the case as just part of a longer journey that began and ended in the legislature. So it's ultimately the legislature, not the courts, that took decisive action on this question of how should we regulate these types of consumer contracts. And it was a result of legislative action. You get a new regulatory regime for boilerplate in installment sales contracts. And that new regime, I think, only emerges because of this dialogue between the courts and the legislature. So the implications for this, for how lawyers theorize the role of courts and legislatures in policing consumer credit, I think there are a couple. So one is, it suggests maybe a different model for how we should think about how regulation develops and for how we should allocate responsibilities between different legal institutions. So a number of both practitioners and scholars have written about the problem of policing boilerplate in consumer contracts. And they frame this problem often as an issue of institutional choice. Do we let the market or the courts or the legislature supply the terms and police the terms of these contracts? But if we think of this as static, I think we're missing a dimension of what actually goes on in practice. So if we look at what happens in the Williams case, and I would suspect in similar cases, we show that these institutions are actually interacting with one another. If we look, rather than taking things as a moment in time, if we look over a long time span, that there's actually a dialogue that can go on that can yield a new regulatory regime. And so we should think of this really as a process that plays out over time rather than just a moment where we select an institution and leave it to that institution to do the work. I think it also suggests for practitioners a different way of thinking about the role of courts and of evaluating the success of litigation. So if we think of the success of litigation as just tallying wins and losses, and certainly for the client, the win or the loss is very important. But if we're thinking about a larger campaign for some sort of legal change, looking just at the outcome of cases is too short-sighted. We should instead think about what's happening outside the courts as well as what's happening in them. So for Ms. Williams, the case did end in settlement, but that's not the full story, right? For other borrowers like Ms. Williams, litigation served to raise the salience of this problem that was going on in the low-income marketplace and drew public attention to something that was happening on the ground, which then fueled a debate in the political branches leading to statutory reform. So I think litigation, although it's very resource intensive and often only leads to an outcome for a specific client, can still have an important role in sort of thinking about larger legal change and law reform. And particularly for low-income consumers whose problems are not necessarily often the focus of public discussion, litigation can serve to kind of raise the profile of some of these concerns that we may have and push towards a debate in the political branches that can yield a new regulatory regime. So in my brief time remaining, I just want to offer a second example that complicates the story a little bit that I just told. So a second example that might revise our theories about how law works in practice, generate new theories, and also theoretical conclusions of use to practitioners. So I stopped my story in 1971 when Congress enacts this new legislation for DC. But of course, it's 2017. The story doesn't stop in 1971. And in fact, commercial practices don't stand still in the face of new regulation. So Walker Thomas Furniture goes out of business. Many other stores like it also go out of business. And today, the institutions that serve a similar clientele are rent-to-own stores. So chains like Rent-A-Center, Aaron Rents, they serve a similar clientele and provide similar services, but offer a slightly different product. So rather than selling goods on credit, rent-to-own stores lease furniture and other consumer goods to their customers on a weekly or monthly payment schedule. So the deal is functionally very similar to an installment sale in function, but not in legal form. And in fact, the rent-to-own industry, when it started growing in the 1970s, argues very forcefully that these transactions are really leases, not credit sales, and so should not be governed by consumer credit legislation, including legislation like the 1971 legislation enacted in the wake of the Williams decision. Consumer advocates, of course, disagree, and the question again makes its way into the courts. And so after that, after there are some court cases, we see in the 1980s many states adopt legislation specifically regulating rent-to-own transactions. So given the story I just told you about how DC's 1971 legislation came about, you might look at these state rent-to-own laws and think you know where they came from, right? So one story we could tell is that the states were again learning from the court decisions, that litigation surrounding rent-to-own alerted state legislatures that again there was an ongoing problem that existing rules were not sufficient to police this business, and so there was a need for additional regulation. But in fact, what happened is a little bit different. So litigation around rent-to-own transactions in the late 70s and early 80s generated a lot of uncertainty for the rent-to-own industry, which was still pretty new, and was in search of some sort of legitimacy, stability, as it was growing from a bunch of sort of small mom and pop stores in the 50s and 60s into a large national industry. So after the first lawsuits, trying to decide this question of what are these transactions, are they leases or are they credit sales, after those lawsuits get filed, the rent-to-own dealers organize. So they form a national trade association in 1980, the Association of Progressive Rental Organizations, and they then began lobbying for legislation on a state-by-state basis. So the legislation that is on the books in most states didn't come from concerned consumer advocates responding to the outcome of court litigation. In fact, it was the result of an organized industry lobbying campaign to ensure the stability of the legal environment for the business going forward. So by the early 1990s, over 30 states had adopted some version of this industry-sponsored legislation. So again, that story supports a different theory about the relationship between regulation and business than the story that you might derive from these facts, which is, again, the courts are generating issues for the legislature to solve, right? So the first story, the story that the litigation prompted consumer advocates to go to the legislature and seek out change, suggests that regulation happens in response to public and consumer-minded advocates, often over the objection of business, right? The other story, the second story, is in fact kind of the opposite of the first. So it suggests that in fact, in some instances, business seeks out regulation. And specifically that business will embrace regulation when in search of stability and legitimacy, because regulation can create certainty in an otherwise uncertain legal climate. So again, for legal practice, I think what this tells us is that focusing strictly on litigation as a tool of law reform can be short-sighted, right? So litigation can in fact create such uncertainty for an industry that the industry pushes for legislative change. And the direction of the change won't necessarily follow what consumer interest groups might want. If the business is sufficiently well organized, sufficiently legally sophisticated, like the rent-to-own industry was in the 1980s, it may push to guide the legislative reform and may push for rules that better protect its interests and may care less about protecting the consumer interests. So I will stop there in the interest of time.
Question over here. Somebody got a question. Yes.
It was for the previous talk, but I think this was a fascinating talk. And I'm wondering, how would you teach after this fascinating story? And we are in a contract law class. How would you teach now Walker Thomas and the doctrine of unconscionability to your 1L student? And for Kurt, I had another quick question, which is the story you tell about the split between the progressive and the realist resonates with what happened also in European legal theory with the same split, with the consequence that the progressive then turn out, many of them, to ally with fascism and National Socialism, and not seeing the consequences that you're talking about. So I think not only the consequences are, you talked about policy consequences, but there were also real-life political consequences in certain contexts.
Thank you.
I can start. So I have a lot of trouble teaching the Williams case just because I feel like in some ways I know more about it than is useful for teaching. So I, at least the first part of the class that I'm teaching it, I really probably teach it in the way that most everyone else does, focusing on, okay, what's the rule to the extent that there's a rule in the decision, how does the rule get applied, what's the outcome. But then we do talk kind of about the policy concerns surrounding unconscionability, which I describe to my students as a very squishy doctrine. So there's a lot of play in the joints, there's a lot of room for discretion. And so we talk about, is this actually a good way to go about policing contract terms? And if it's not, is there something else we can do? And I feel like for first-year students particularly, because we're so focused, I mean, we talk about the UCC, but we really talk about the UCC, common law. There's this whole, universe of statutes that don't come into the class very often, and so that's the moment where you can sort of highlight, even though this class is focused on this body of law, there's actually many other things that we would need to take into consideration if we were fully understanding how these types of contracts were regulated.
As Professor Fernanda Nicola, I presume, nice to meet you. She's going to be in the third session.
Second part of good questions.
Okay.
I have thought about this myself too. It seems like whenever the courts, perform this signaling function for legislatures, something happens that I think is kind of unfortunate. The example I would use is very similar to yours, is habitability. The courts were the first one to make a warranty habitability, and that was criticized because it puts all the costs on landlords. The landlords then fix the units. It actually reduces the number of units for the poor and economic hurt. But it did perform that same signaling function. What happened is after the courts decide there's a warranty habitability, the legislatures come in and they codify it. But what kind of happens, I think, is that sometimes the legislatures come in and they don't act on the strengths of legislation. They almost adopt the adjudicative result, or the court-based result. They come up and define rights. I mean, a legislature could say, with poor housing, increase the amount of Section 8 allowances, or do all kinds of legislative things that courts can't do. But what they end up doing, because the conversation has been started by the courts, is they end up thinking like courts. And I just would wonder what your comment on that would be.
Yeah, that's a really great point. So I guess the question is there something, right? Because I think the courts are still providing a valuable,
right?
They're playing a valuable role in that process, but it suggests to me at least that there's something missing, right? That you can't just take the court decision and then write it into a statute and consider your job done, that there's actually some role, again, maybe for legal theory and thinking about what are the strengths of legislative responses as opposed to judicial responses, and what can the legislature, as you said, do that the courts can't do. And I don't know whose job it is in that process to kind of raise that concern, but it could be, whoever is working with the legislature to help draft the legislation, or, it could be some outside group, but it suggests that just picking up on the court decision and putting it into a statute is not the right way for the legislature to think about what its job is.
Yeah, well, just another disclosure. I, being a 24-year Uniform Law Commissioner from Massachusetts, and having participated in the attempt to revise Article 2 and 2A, and actually introduce on my own behalf UCC Article 2B, just notice that experiment was a complete failure.
Yeah.
And two, now my question to you is the more recent consideration by the American Law Institute on the restatement of consumer contracts, dividing into two regulatory areas, namely the assent portion, which is thrown up its own hands on, so forget it, and the idea of revitalizing the idea of unconscionability. And the answer back has been from the tort reform folks, and actually from my practice, why does it even matter, because arbitration clauses get there.
Yeah.
And the idea is that if you believe that the Consumer Finance Protection Board is going to survive this administration, or that it could do anything against the Federal Arbitration Act, what's your thinking?
Yeah, I mean, so it's interesting to see the approach that the drafters of the restatement have taken, which seems to be attempting to actually restate the law, but also, I mean, like all restatements, right, it's partially restating and partially pushing it in a direction.
Well, it actually changed. There's a new definition of what restatements are. which is really that restatements are there to influence courts. Principles are there to influence best practices, which is different from the original deal with restatements.
Right, okay. Well, that's, yeah, certainly comports more with what the statement is shaping up to be. Yeah, so I think the idea of sort of allowing easy entrance into a contract, right, not throwing up a lot of barriers to assent, and then relying on documents like unconscionability to kind of do the policing at the back end, only works if A, as you said, there's no pushing into arbitration, and then, you know, B, if there are lawyers willing to take these cases. So one of the things we talk about in 1L contracts is, you know, the downside of using unconscionability as a way to police contract terms is it's really hard for someone without a lawyer to assert an unconscionability claim. I mean, it's hard for lawyers to assert them, and somebody who's not a lawyer is not going to have the understanding of the law or, you know, the ability to kind of frame it in a way that would be most persuasive to a court. So if we are assuming that most consumers don't have lawyers and, you know, the availability of class actions may be limited, then it doesn't seem like, to me, it would be necessarily a very effective way of preventing overreaching by the non-consumer.
Well, I'm going to ask one quick question, then we're going to take a break. We're going to take a break, and some snacks are going to come in, so people can have, they're on the way, so they'll be in shortly. And then you can have snacks, we'll take 15 minutes or a little more, and we'll start at 3:25. But my question to anybody here on the panel is, if you have reform legislation instead of litigation, do you prefer an open textured statute, or do you want one that's real tight? Because if you've got one that's real tight, you're into dealing out the decisions that are made. Go ahead. You want an open texture. I guess there is. Does that make any sense? Makes my question make sense?
Yeah, no, I think I understand the question. Yeah. So, I mean, I think for, again, it comes back to, do you have a lawyer, do you not have a lawyer to actually enforce whatever the rule is. So if it's open texture, that suggests that it probably would be difficult to assert whatever the claim is without the guidance of a lawyer, right? So whereas if it's a bright line rule, like the rule that you cannot have pro rata allocation of payments under an installment contract, that you don't need to be a lawyer to assert. So I think you need a mix of them. For things that you absolutely want banned, it should just be a bright line rule. But you still have to have standards because commercial practices are constantly changing, and as soon as you set the rule, the practice will just move to the other side of the rule. So you have to have something to kind of police what's going on over here.
Anybody else? Okay, let's take our break, and we'll reconvene. Thank you very much.